Welcome back to the channel. If you're studying for the UBC Real Estate exam, you're in the right place. In this video, we'll go over 20 practice questions from Chapter 1 of the UBC Real Estate Manual to help you ace your exam. Whether you're just starting out or need a refresher, these questions will test your knowledge and give you the confidence to succeed. Chapter 1. Practice questions. There are several steps taken before a lawsuit actually is brought before a judge. Which of the following procedures does not take place before a trial begins? A. Filing and serving a notice of civil claim. B. Filing and serving a response to civil claim. C. Conducting an examination for discovery. D. Obtaining a garnishing order. The procedure that does not take place before a trial begins is obtaining a garnishing order. Explanation. Filing and serving a notice of civil claim. This is the first step in initiating a lawsuit, where the plaintiff outlines their claims against the defendant. A. Filing and serving a response to civil claim. The defendant responds to the allegations, which is a critical pretrial step. B. Conducting an examination for discovery. This process allows both parties to gather evidence and clarify facts before the trial. C. Obtaining a garnishing order. This is a post-judgment or interim enforcement mechanism to secure money from the defendant, e.g., wages or bank accounts. It is unrelated to the steps leading up to a trial and typically occurs after a judgment is granted. Which of the following falls within the category of law called public law? 1. Breach of contract. 2. Trespass. 3. Constitutional law. 4. None of the above. The correct answer is constitutional law. Explanation. Public law deals with the relationship between individuals and the government, as well as the structure and operations of the government itself. Examples include constitutional law, criminal law, and administrative law. Breach of contract and trespass fall under private law, as they involve disputes between individuals or organizations rather than matters involving the government or public interest.
Which of the following statements concerning the equitable jurisdiction of the court is true? Where the rules of equity and common law conflict, the court will apply the common law rule. Equitable remedies are available to parties in a court action as of right, regardless of their conduct. The rules of equity developed as a remedy for the rigidity of the common law in England. Specific performance, injunctions, and legal damages are three types of equitable remedies. The correct answer is, the rules of equity developed as a remedy for the rigidity of the common law in England. Explanation. Equity evolved to address the limitations and rigidity of common law, offering more flexible remedies like injunctions and specific performance when legal remedies like damages were insufficient or inappropriate. The first statement is false because, when there is a conflict between equity and common law, equity prevails. The second statement is false because equitable remedies are not available as of right. They depend on factors like fairness and the conduct of the parties involved. For example, a party must act equitably to obtain an equitable remedy. The last statement is false because legal damages are not considered an equitable remedy. They are a legal remedy. Equitable remedies typically include specific performance, injunctions, and rescission, not legal damages. Which of the following statements is false? In a conflict between common law principles and equitable principles will prevail. In a conflict between common law principles and statute law will prevail. In a conflict between statute law and equitable principles will prevail. In a conflict between equitable principles and statute law will prevail. The correct answer is, in a conflict between statute law and equitable principles will prevail. Explanation. Statute law, legislation passed by a governing body, takes precedence over both common law and equitable principles. Courts must follow statutes when they apply, regardless of equitable principles. The other statements are true. Equity prevails over common law in case of a conflict. Statute law prevails over common law. Statute law prevails over equitable principles as well, making the third statement false.
When a judge distinguishes a case on its facts, this means the judge decides that facts crucial to a former decision are not present in the case at hand, and does not follow the former decision. The judge formally reports the case before them because it is a crucial decision. The judge follows a former decision because the same facts exist in the case that is being decided. The judge refers the case to an appeal court because of its difficulty. The correct answer is, the judge decides that facts crucial to a former decision are not present in the case at hand, and does not follow the former decision. Explanation. When a judge distinguishes a case, they are recognizing that while a previous case may have legal principles that are relevant, the facts in the current case are sufficiently different that the earlier decision does not apply. As a result, the judge may not follow the precedent set by the previous case.
A new furnace that Sally installed in her house exploded 6 months after installation. Sally intends to bring a lawsuit against the manufacturer. What is the first document that Sally's lawyer will file? A response to civil claim, a notice of trial, a notice of civil claim, a garnishing order. The correct answer is a notice of civil claim. Explanation. The notice of civil claim is the first document that Sally's lawyer would file to begin a lawsuit. It outlines the claim, the parties involved, and the details of the legal action being taken. This document formally initiates the legal process. B. A response to civil claim is filed by the defendant in response to the notice of civil claim. C. A notice of trial is filed once a case is ready to go to trial, after initial pleadings are exchanged. C. A garnishing order is used to collect a judgment after a lawsuit has been won and typically applies to wage or bank account garnishment.
Which of the following is not a possible meaning of the term common law? A. The law created by the courts as opposed to statute law. B. The principles derived from the common law courts in England as opposed to the principles derived from the courts of chancery. C. The laws created by the federal government in accordance with its power under the Constitution. D. The system of law which relies upon the principle of stare decisis for its development. The correct answer is, the laws created by the federal government in accordance with its power under the Constitution. Explanation. A. Common law refers to law that is developed through judicial decisions and precedents rather than through legislative statutes or executive orders. B. The law created by the courts, as opposed to statute law, is a key characteristic of common law. C. The principles derived from the common law courts in England versus those from the courts of chancery refers to the historical distinction between common law and equity. D. The system of law which relies on stare decisis refers to the principle of following precedents established by prior court decisions, which is a hallmark of the common law system. The federal government creating laws under the Constitution refers to statute law, not common law.
A government may pass a statute in order to do which of the following? A. Change the common law. B. Develop a system of precedent. C. Alter the constitutional allocation of legislative authority between the federal and provincial governments. D. Publicize an important judicial decision. The correct answer is change the common law. Explanation. A government may pass a statute to change the common law, as statutes can override or modify existing common law principles or fill in gaps left by common law. Developing a system of precedent is a function of the courts, not the legislature. Precedent is established through judicial decisions, not statutes. Alter the constitutional allocation of legislative authority would involve a constitutional amendment, not a statute, as the Constitution governs the division of powers. Publicizing an important judicial decision is typically done through court rulings or publications, not through the passage of statutes. Which party to a court proceeding files a response to civil claim? A. The plaintiff, B. The accused, C. The defendant, D. The prosecutor. The correct answer is the defendant. Explanation. A. In a court proceeding, the defendant is the party who files a response to civil claim. This document is the defendant's formal reply to the claims made by the plaintiff in the notice of civil claim. B. The plaintiff is the party initiating the lawsuit and files the notice of civil claim. C. The accused typically refers to a party in a criminal case, not a civil case. the prosecutor represents the government in criminal cases, not civil cases. Which of the following statements about the trial process in British Columbia is false? A. Our common law system is based on an adversarial process in which each of the two opposing parties presents its point of view to an impartial trier of fact whose decision is binding on both parties. B. A plaintiff commences an action by filing a notice of civil claim in the court registry. Once served with the notice of civil claim, the defendant can answer by denying some or all of the claims set out in the plaintiff's notice of civil claim by filing a response to civil claim. One of the major reasons why most claims are settled out of court is that the discovery process allows the parties to see more plainly the strengths and weaknesses of their positions. D. The plaintiff and defendant alternate in calling their witnesses. The correct answer is the plaintiff and defendant alternate in calling their witnesses. Question 11. Which of the following statements is true? A. An appeal from all courts of original jurisdiction in British Columbia, including small claims court, is to the British Columbia Court of Appeal. B. An appeal from the British Columbia Supreme Court is to the British Columbia Court of Appeal. C. A person who loses in the British Columbia Court of Appeal has an absolute right to be heard in the Supreme Court of Canada. D. An appeal from small claims court is heard by 3, 5, or 7 judges. The correct answer is an appeal from the British Columbia Supreme Court is to the British Columbia Court of Appeal. Explanation A. An appeal from the British Columbia Supreme Court, which is the province's trial-level court for most serious cases, goes to the British Columbia Court of Appeal, which is the province's appellate court. B. The statement about an appeal from small claims court is false because small claims court decisions are typically appealed to the British Columbia Supreme Court, not directly to the Court of Appeal. A person who loses in the British Columbia Court of Appeal does not have an absolute right to be heard by the Supreme Court of Canada. The Supreme Court of Canada hears cases at its discretion, typically involving national or constitutional importance. Appeals from small claims court are not typically heard by a panel of 3, 5, or 7 judges. Instead, the appeal is heard by a single judge from the British Columbia Supreme Court. When commencing a lawsuit in small claims court, the plaintiff may originate the action in which of the following jurisdictions? A. Where either the plaintiff resides or the defendant resides. B. Where the plaintiff resides only. C. Where either the cause of action arose or the defendant resides. D. Where either the cause of action arose or the plaintiff resides. The correct answer is where either the cause of action arose or the plaintiff resides. Explanation. When commencing a lawsuit in small claims court, the plaintiff can file the action in the jurisdiction where 1. The cause of action arose, i.e., where the event or issue that led to the lawsuit occurred, or 2. The plaintiff resides, i.e., where the plaintiff lives. This provides flexibility for the plaintiff to choose a convenient jurisdiction for initiating the case. The defendant's location is not the primary factor in this context. Question 13. Which one of the following statements is false? A. The doctrine of stare decisis provides uniformity to the common law system. B. The Supreme Court of Canada is not required to hear all appeals. C. The Supreme Court of British Columbia may exercise both common law and equitable jurisdiction. D. An appeal by a taxpayer to reduce a tax assessment would fall within the sphere of private law. The correct answer is an appeal by a taxpayer to reduce a tax assessment would fall within the sphere of private law. Explanation. An appeal by a taxpayer to reduce a tax assessment falls within the sphere of public law, not private law. Public law governs the relationship between individuals and the government, and tax disputes involve the government's authority over taxation. The other statements are true. A. The doctrine of stare decisis ensures that courts follow precedents, promoting consistency and uniformity in the law. B. The Supreme Court of Canada is not required to hear all appeals. It has discretion to select cases of national significance. C. The Supreme Court of British Columbia has both common law and equitable jurisdiction to address a range of legal issues. Question 14. Which of the following could be called legislation? A. The Land Title Act. B. The Principle of Specific Performance. C. The Equity of Redemption. D. All of the above. The correct answer is the Land Title Act. Explanation. Legislation refers to laws that are passed by a governing body, such as a statute or act. The Land Title Act is an example of such legislation, as it is a law passed by a legislature to govern land titles. The other options are not legislation. The principle of specific performance is an equitable principle, not a statute. It is a remedy in equity where the court orders a party to fulfill a contractual obligation. The equity of redemption refers to a concept in property law, specifically in the context of mortgages, but it is not a statute. It relates to the right of a borrower to redeem property after foreclosure. Which one of the following does not fall within the body of public law? A. Tax law, B. Criminal law, C. Agency law, D. Constitutional law. The correct answer is agency law. Explanation: public law governs the relationship between individuals and the government or between different government entities. The options that fall under public law are: tax law governs the relationship between individuals, businesses, and the government regarding taxation. Criminal law regulates offenses against the state or public and includes prosecutions by the government. Constitutional law deals with the structure and functioning of government institutions and the relationship between the state and individuals. Agency law, however, falls under private law, as it governs the relationships between principals and agents, typically in private matters rather than public or governmental contexts. Question 16. Where a case is brought before a judge of the British Columbia Supreme Court, which of the following actions may be taken by the judge? A. The judge may only exercise equitable jurisdiction in deciding the matter. B. The judge may exercise both equitable and common law jurisdiction in deciding the matter. C. Where common law and equity conflict, the judge must apply the common law rule. D. The judge may not do any of the above. The correct answer is B. The judge may exercise both equitable and common law jurisdiction in deciding the matter. Explanation: the British Columbia Supreme Court has both equitable and common law jurisdiction, meaning it can apply principles from both areas of law when deciding a case. Equity and common law were originally separate bodies of law, but they have since been merged in many jurisdictions, including British Columbia. As a result, a judge can apply both principles as appropriate, depending on the nature of the case. A is incorrect because the judge is not limited to only equitable jurisdiction. They can use both. C is incorrect because when common law and equity conflict, the principle of equity prevails. D is incorrect because the judge can indeed exercise both types of jurisdiction in a case. Question 17. What is the result of the doctrine of stare decisis? A. Former decisions are used as a basis for later decisions. B. The common law system has uniformity. C. Decisions by the Supreme Court of Canada are accorded the most weight in our jurisprudence. D. All of the above result from the doctrine of stare decisis. The correct answer is D. All of the above result from the doctrine of stare decisis. Explanation: stare decisis is the legal principle that dictates that courts should follow precedent, previous decisions made by higher courts when making rulings in similar cases. A. Former decisions being used as a basis for later decisions is a core element of stare decisis. B. The common law system is known for its uniformity because courts rely on past decisions to guide current rulings, leading to consistent application of the law. Decisions by the Supreme Court of Canada are indeed accorded the most weight because the Supreme Court is the highest court in the country, and its rulings serve as binding precedents for all other courts. Thus, all of these outcomes result from the doctrine of stare decisis. Question 18. An appeal from the Small Claims Court is to which of the following? A. The British Columbia Supreme Court. B. The Federal Court of Appeal. C. The British Columbia Court of Appeal. D. The Small Claims Court of Appeal. The correct answer is A. The British Columbia Supreme Court. Explanation: appeals from Small Claims Court are made to the British Columbia Supreme Court. The British Columbia Supreme Court hears appeals from Small Claims Court, typically conducted by a judge alone, and does not involve a jury. The Federal Court of Appeal and the British Columbia Court of Appeal handle appeals from federal and provincial higher courts, respectively, not directly from Small Claims Court. There is no Small Claims Court of Appeal in British Columbia. Appeals from Small Claims Court go to the British Columbia Supreme Court. Question 19. The term stare decisis means A. On the surface, B. Let the former decision stand, C. Beyond the powers, D. Decisions must be equitable. The correct answer is let the former decision stand. Explanation. Stare decisis is a Latin term that means let the former decision stand. It is a fundamental principle in the common law system where courts follow precedents set by previous rulings to ensure consistency and predictability in the law. Question 20. When a judge in the British Columbia Supreme Court exercises equitable jurisdiction, A. They may refuse to apply any law that is unfair. B. They may grant such remedies as specific performance or an injunction. C. They may refer to a code to ascertain the law on a particular matter. D. They may do all of the above. The correct answer is they may grant such remedies as specific performance or an injunction. Explanation. Equitable jurisdiction allows a judge to grant remedies based on fairness rather than just applying strict legal rules. Some common equitable remedies include specific performance, forcing someone to fulfill a contract, and injunctions, orders to do or refrain from doing something. The judge does not have the authority to refuse to apply any law simply because it is unfair. The judge must still consider the law in the context of equity. Judges in equitable jurisdiction do not typically refer to a code to ascertain the law, as equity operates through principles that are shaped by past judicial decisions and fairness rather than being codified like statutory law. Question 21. Which of the following is the correct chronological order of some of the procedural steps involved in the trial process in British Columbia? A. Conducting an examination for discovery, filing and serving a notice of civil claim, filing and serving a response to civil claim, enforcing a judgment. B. Filing and serving a response to civil claim, filing and serving a notice of civil claim, enforcing a judgment, conducting an examination for discovery. C. Filing and serving a response to civil claim, conducting an examination for discovery, filing and serving a response to civil claim, enforcing a judgment. D. Filing and serving a notice of civil claim, filing and serving a response to civil claim, conducting an examination for discovery, enforcing a judgment. The correct answer is filing and serving a notice of civil claim, filing and serving a response to civil claim, conducting an examination for discovery. Enforcing a judgment. Question 22. In Canada, the power to make laws is divided between the federal and provincial levels of government. Which of the following has not been assigned to the federal government? A. Jurisdiction over harbors. B. Jurisdiction over matters affecting private property and the power to delegate some provincial authority to a third level of government. C. Jurisdiction over postal services. D. Jurisdiction over the regulations to protect fisheries. The correct answer is jurisdiction over matters affecting private property and the power to delegate some provincial authority to a third level of government. Explanation. In Canada, the power to make laws is divided between the federal and provincial governments according to the Constitution Act 1867, formerly the British North America Act 1867. A. Jurisdiction over harbors is within the federal government's jurisdiction, as it falls under the federal power to regulate navigation and shipping. C. Jurisdiction over postal services is also a federal responsibility, as the federal government controls the postal system. D. Jurisdiction over regulations to protect fisheries is a federal power, as fisheries and matters related to them are regulated by the federal government under its authority over trade and commerce. However, B. Jurisdiction over matters affecting private property and the power to delegate some provincial authority to a third level of government is primarily within the provincial jurisdiction. The provinces have authority over property and civil rights, Section 9213 of the Constitution Act 1867, and the power to delegate authority to local governments lies within provincial jurisdiction. Therefore, this is not a power assigned to the federal government. Question 23. Which of the following would not be available to a judgment creditor as a means of enforcing a judgment? A. Examination of the judgment debtor under oath. B. Obtaining a writ of execution so that the judgment debtor's personal car can be seized and sold. C. Obtaining and serving a garnishing order on the judgment debtor's bank. D. Registering a notice of civil claim in the appropriate land title office against the judgment debtor's property. The correct answer is registering a notice of civil claim in the appropriate land title office against the judgment debtor's property. Explanation. Examination of the judgment debtor under oath. This is a legal process where the creditor can examine the debtor to uncover assets or other means to enforce the judgment. Obtaining a writ of execution so that the judgment debtor's personal car can be seized and sold. A writ of execution is a court order that authorizes the seizure and sale of the debtor's property to satisfy the judgment. Obtaining and serving a garnishing order on the judgment debtor's bank. A garnishing order allows a creditor to seize money directly from the debtor's bank account, wages, or other sources of income to satisfy the debt. However, registering a notice of civil claim in the appropriate land title office against the judgment debtor's property is not a means of enforcing a judgment. A notice of civil claim is used to initiate a lawsuit, not to enforce an existing judgment. For enforcement, a writ of execution or other enforcement measures must be taken.